now in session.
Please be seated. This is the time scheduled for oral argument in Hardy versus Gottlieb, our case number civil 120631. Each side's been allocated 20 minutes for oral argument. If the appellant desires to appellants desire time for rebuttal, you may do so, but the clock in the podium shows you how much time you have left, including your rebuttal time. So you have to manage your own time. Don't feel any need to take up all 20 minutes. If you're done speaking and we don't have any further questions, feel free to sit down. To assist you, we've reviewed the briefs, the record, the case law, and are relatively familiar with the facts and the law and the issues presented. Finally, be aware that we are now audio and video recording these proceedings. So when you approach the podium, first state your name and who you're representing. Smile for the cameras because you will be on TV or video recording, and then proceed. So with that, counsel for the appellants.
Good morning. My name is Nathan Fidel of Harrelson, Miller, Pitt, Feldman, and McAnally. With me is Justice Stanley Feldman. We represent the Hardys. What I'd like to do is use about 10 minutes for myself, and I'll reserve 10 minutes for rebuttal, at which point Justice Feldman is going to handle the rebuttal. We think that the case law is straightforward on this, and the facts are straightforward too. The expert, Dr. Carol Holland, was certified as a plastic surgeon. Dr. Gottlieb, the doctor whose treatment is the issue of the underlying malpractice lawsuit, was also certified as a plastic surgeon at the time that the treatment at issue was taking place. On this record, there is no certification that has been presented to this court for Dr. Gottlieb as a wound care specialist. CMET, which was presented to this court by the appellee, CMET, I believe, is the...
Well, let's deal first with the law of the case.
Sure.
We have a very persuasive decision of this court in Hardy 1.
Right.
But it appears to me that what the trial court was doing, and maybe I'm wrong, tell me if I'm wrong, was basically only deciding the law of the case, not going to the other issues. Baker 1, I guess, was decided at the time he ruled and made his ruling, but it doesn't appear that he relied on it. And as I read the minute entry, it looks more like he's deciding the law of the case. But law of the case can't apply, one, if we aren't deciding the issue as to Dr. Gottlieb, and two, if there's been a change in the law, which there now is. So do we reverse just on the law of the case?
Well, I don't think you can use, I don't think the trial court could use law of the case to reach its decision. And
that's what it was doing, right? I mean, that's my question really is that's what it was doing, wasn't it?
That's what it was doing. The trial court decided that the specialty at issue was wound care.
Okay.
But the law at that time, Baker 1, specifically stated that wound care could not be a specialty as the statute was written. So the trial court ignored Baker 1 to reach its decision, and is an extra sort of foundation for its decision that cited the law of the case to get there, because in this the previous appeal, which you wrote, it takes for granted that the specialty is, and maybe take for granted isn't the right thing.
That was nursing care, but
Sure.
It was persuasive at the time.
Okay.
But it implied that wound care might be, at least as far as, but it's really aimed more at the nursing care issue. So, but it doesn't matter because the law's changed. So law of the case doesn't apply if the law changes, right?
Correct.
Okay.
So
then what do we do about let's assume that we reversed on law of the case. Hypothetically, I'm not saying we're doing that, but assuming that we did, saying judge was wrong, this is not law of the case. What do we do with the CMET? Because first of all, Baker 2 comes down after, while the appeal is pending.
Sure.
And now it looks like there's disputed issues of fact about, well, was CMET actually certifying people at the time this procedure was done? Because I think that's the standard, I think. Dr. Gottlieb says, well, CMET does certify or recognize a certification. Then there's some arguments in the answering brief that talk about, the reply brief that say, wait a second, they didn't even do this at the time. Isn't that something we have to remand to the trial court for?
I think that's fair if the trial court can decide those issues. But if you do that remand, it's important to at least instruct that that the parties have the opportunity, if the trial court determines that wound care is the appropriate standard, that the parties have the opportunity at this point to go out and get a wound care specialist.
And that's because the law has changed.
Correct. I don't know that there's anything else I really have to add.
Okay. Thank you.
Thank you.
That was quick. May it please the court, Robin Burgess on behalf of the appellee, Dr. Gottlieb. Let me just start, I guess, with the comments that you made regarding what the law of the case requires it to be remanded simply because the law has changed. And if the issue purely was, is this a wound care specialty, subspecialty or not, then that may be an appropriate inquiry. But the other issue to look at is whether the original trial court determination and all of the determinations by actually two different trial judges as well as the appellate court complies with other indicia of whether or not this doctor, Dr. Holland, is an appropriately qualified expert in order to testify against Dr. Gottlieb for the kind of care at issue in the case.
Well, we're dealing with the statute, though. The statute talks about specialties and then subspecialties, and Baker 2 makes clear that someone's got to be certified at the time of, at least in my mind, I think it makes clear that someone has to be certified by some peer review organization to do that kind of, as a subspecialty. Isn't that what we're really, I mean, whether there's other indicia, that's the standard. That's the statute. We're talking about statutory interpretation.
I think that the statute and Baker are starting points for the court to determine whether an expert is qualified, but there are other analyses that the trial court has to undertake in order to determine if someone is qualified as an expert. I think looking at the statute, you're saying, okay, the legislature has said to us as a threshold matter, these people, we have to evaluate as a trial judge, are these experts truly experts? Are they certified in the appropriate areas of care? But then the secondary question becomes, regardless of the certification, is the doctor truly qualified under Rule 702 Rule of Evidence, as well as the Med-Mal statute, which is 12563, that requires that a testifying expert explain to a jury how one acts in the same or similar circumstances as the doctor whose care is in question.
But this trial judge did not address those issues. As I understand and have read the ruling, I think Judge Kessler made this point as well, the trial judge here basically applied law of the case and found that Mr. and Mrs. Hardy's expert or basically excluded the expert. And the law has really changed with Baker too. And so those are issues that you have raised, and they're good issues, and they need to be explored, but we're not the trial court. So if, in fact, the decision was only on law of the case, and if that was an incorrect determination, an incorrect application now because of Baker 2, then isn't the solution to remand and have the trial court now look at this issue again? And you can make all those additional arguments in the proper forum.
If we're only looking at Judge Foster's decision, where he determined the issue is law of the case, then that may be the case. The problem we have here is this case has quite a history. And if you go back to the original trial judge, Judge Hicks. Judge Hicks had a hearing where she vetted out information regarding Dr. Holland's qualifications, and actually on the record stated, don't you agree with me that Dr. Holland is just not qualified to address the kind of care referenced here?
Wait. The care referenced here in relation to what?
Well, she was actually asking the attorney for the hospital to agree with her.
Which
that
hospital? Sorry,
it was
which
St.
hospital?
Joseph's Hospital, I believe, at the
Which
time.
is the nursing care.
Correct, but she was asking that attorney whether he agreed with her determination that Dr. Holland was not qualified to render an opinion against Dr. Gottlieb because Dr. Gottlieb was tending to wounds and Dr. Holland was not qualified. At the time, the attorney said, well, I'm not really going to get into that. Then when that issue, though, went up on appeal, because Judge Hicks ultimately concluded that neither Dr. Holland nor the nursing expert in the case were qualified to address wound care issues, period, end of conversation. On appeal, the first court that addressed this issue looked at both of those two experts and determined that Dr. Holland, and went through the analysis in the statute, that Dr. Holland did not have the qualifications necessary to address the type of medical care that is at issue. They didn't talk about her subspecialty. They didn't talk about any certification.
We even said that.
But what they did address is what her actual background
As it
was.
related to the nursing care.
Well, they conclude that because the issue was the nursing care, she wasn't qualified, but I don't think that they qualified the entire analysis as being limited only to nursing care. They made it very clear Dr. Holland has no wound care experience, and in fact, in the briefing here before this court, the appellant says she has no wound care qualifications.
You wouldn't have expected us to say, well, we don't care what the issues are. We're going to say she doesn't have wound care, so under 701 or 702, even though it's not before us, she isn't qualified to testify. That's not what,
I think
we
it
don't even.
supports what the trial court did. I think it supports the ultimate determination made by both of the trial judges, as well as the first appellate court that looked at whether Dr. Holland is somebody who is a true peer of Dr. Gottlieb, who brings the requisite knowledge.
But we didn't have Dr. Gottlieb before us on the first appeal. All we had was the St. Joseph's nursing staff. And as related to the nursing staff, that might be correct. But we don't know what, we didn't have the record or anything else about Dr. Gottlieb and Dr. Holland before us as to that. And in any event, once that occurs, I get back to the statute. The statute, Baker 2, says what we need to, that's the issue before us, is under that statute is Dr. Holland qualified under the statute to be the person designated to testify? And the answer is, you can't go on the law of the case because the law has changed. If on remand, the court determines that, yes, they were both certified in, or that no CMAT, the CMAT certification doesn't count for whatever reason, then you can, as Judge Norris pointed out, you can raise all these additional issues, but they're not before us.
So I guess what you're saying is that you feel that we're only addressing the statute, not whether, generally speaking, the statute is only one piece of the analysis.
We're only addressing the statute, as far as I know.
All right. Well, then, under those circumstances, obviously the statute says what the statute says, and Baker interprets it, and there was not a full record, because frankly, obviously, Baker 2 wasn't even an opinion when this briefing occurred.
It was
So
sort of still in the oven.
It was cooking. Yes, it was. And so obviously the parties did not have the opportunity to develop any of the other information. I think both parties went ahead and tried to provide the relevant documentation information to the court in case the court wanted to evaluate that. But certainly Baker 2, which, I mean, I would just call it Baker. It's the prevailing opinion on the issue. That decision does make it clear that it's not simply certification that is the key. It talks about the fact that you don't have to necessarily be certified in a subspecialty. You could be eligible for certification in a subspecialty. And in this case, very clearly the record even below, before the Baker case came out, made it very clear that Dr. Gottlieb is a wound care specialist. The care he rendered exclusively in his practice was wound care and only wound care. And it's clear that Dr. Holland never has any such experience whatsoever.
Well, but I believe Mr. Fidel made the point that if we reverse and remand, and the court determines that Dr. Gottlieb is the eligible or is in fact certified as a wound care specialist, then they are entitled to have an opportunity to offer an appropriate expert in that eligible or in that or already certified as a specialist.
And we would strenuously disagree with that.
And why is that?
At this point in time, Your Honor, this case has been around since 2007.
I noted the date, yeah.
Dr. Holland was disclosed somewhere in the 2008, I believe, timeframe as the expert. She was deposed in 2009. The parties have thus relied on her testimony and her lack of qualifications for now 2 sets of motions for summary judgment, 2 appeals, to allow them at this point in time, 7
The
years
law's
later.
changed, but I'm very appreciative of that this case is old. Yeah, I mean, that came right and hit me right in the face when I first started reading the briefs a couple weeks ago. Nevertheless, with Baker, the law has changed, and the reality is that the Hardys may need an opportunity to adjust their strategy and their witnesses in light of Baker.
Well, you know, the motions for summary judgment, and particularly the one relating to Dr. Gottlieb, was addressed prior to Baker, even the first Baker. And at that point in time, the argument was that under the relevant statutory scheme, Dr. Holland was not qualified.
That's as to St. Joe's, am I correct, and the nursing care?
The motion for summary judgment filed on behalf of Dr. Gottlieb came subsequently.
Yes, right, yes.
Okay?
Yeah.
And in that motion, at that point in time, the appellants already had been told, let's put Baker aside. At that point in time, the appellants had already been told, Dr. Holland's not qualified as a wound care expert by Judge Hicks and by the Court of Appeals. We go back now
For
to
nursing care, though, that's what the Court of Appeals said. We were not opining on Dr. Holland vis-a-vis Dr. Gottlieb.
Okay, well, the Court of Appeals did say that she's not a qualified wound care specialist. Regardless of who it applies to, the fact is the Court of Appeals did determine she's not a qualified wound care specialist. It went back to the trial judge. The second trial judge had a motion for summary judgment relating to these issues. At that point in time, the appellants had every opportunity to say, you know what, we would like the opportunity to find a new expert. If you, Judge Foster, determine that there is a law of the case that applies here to preclude Dr. Holland, or for any reason want to preclude Dr. Holland, the remedy then would be to allow us the opportunity to get a new expert. They have never asked for that opportunity once until this point in time in the appeal. And I would just argue it's far too late. They've had the opportunity to switch horses when they have already previously been told more than one time that Dr. Holland is problematical. She does not bring with her the necessary experience or qualifications. But they have not asked for that until 6-7 years out from their initial problem.
But the problem of the change of law is really a big problem. Because a party can say, you know, we think our person is qualified under the statute or under any rule to testify in good faith. And they're happy with that person's opinion. And they're making the argument, and they lose, and they take an appeal, and suddenly the law changes and says, you know, for purposes of the statute, that person is qualified or may be qualified. To then say, okay, we're going to have to remand it to the trial court to make that determination on facts. And if you lose, you're out of luck. Seems to me to be pretty harsh. In essence, it would basically almost be saying, well, gee, Baker should be prospective only. And the Supreme Court didn't say Baker should be prospective only. It applied to pending cases.
Correct.
And to require either party to say, well, gee, I've lost my chance because even though I had a good faith argument this person was qualified, I should have tried to find somebody else even though I thought they were qualified, and now 3 or 4 years later, I'm told they're not qualified, or they are qualified, and they're not qualified, I have to get somebody else. Because the law has changed, seems to me to be a pretty harsh result. Even though the delay, I understand the delay, I understand everybody's frustration with that, and, my own view is sometimes those things just happen because the law changes.
Well, it's not just the delay, it's the reliance on, developing the issues early on, but it's also the fact that we're going back prior to either Baker opinion, where there was a very large question mark as to Dr. Holland's qualifications. Right. And that was argued vociferously early on in the case. In Dr. Holland's deposition in 2009, she was asked, do you belong to any wound care societies? No, I do not. Would you be eligible to sit? Would you be qualified to sit for a wound care exam? No, I would not. And so to say, gee, you can switch now to find somebody who can address wound care seems to basically discount all of the information that was available to the appellants early on, where they did have the opportunity to request of the trial court the opportunity to switch experts. They did not take that opportunity. Now, the law has subsequently changed, but that's all after all of this other factual information came up that made it very clear to them that they had a big problem with Dr. Holland. So I guess at this point in time, if you have no more questions, it appears that you want to focus just on the statutory issue. I won't get into all the other arguments relating to the 702 reasons and things like that, why Dr. Holland would not be an appropriate expert in the case.
Sure. Thank you.
Good morning. If the court please, Stanley Feldman with Mr. Fidel for the plaintiff. We're just as unhappy as anybody else over the delay in this case, 7 years. But there's a reason for the delay in this case, and with all respect, it's not attributable to us. The two trial court judges and this Court of Appeals, with all due respect, used the wrong standard in determining the qualification of the witness. And so at every attempt to proceed with the case, we were faced with having to try and get the law clarified, first after Baker 1, then after Baker 2, and here we are today. And yes, there's been a lot of delay, but I don't attribute that to the fault of anybody. Baker 2 clarified what the law is. And as to the questions with regard to what to do on remand, I would submit that, just as we asked in the brief, what to do on remand is what was done in Baker, which is simply remand for the trial, for the parties to, now that the standard is clarified and everybody knows what the standard of a witness should be, then parties can go out and do whatever justice requires on each side to be able to contest the facts of this case as they should be contested.
Hypothetically, there could be a new motion for summary judgment.
Oh, I'm sure. Why not? There's only been
I
five so
understand.
far.
And maybe there will, maybe there won't be. But at least we know, what you're saying is that we know what the standards are now. Baker has clarified what the standard is. And there are factual issues that may or may not need to be developed based on that.
Yes. Excuse me. One point I'd like to make, and to put things in perspective, I bring you now Dr. Fidel over here, all right, who is qualified as an internal specialist in internal medicine and who spent his entire 5 years or 14 years in practice before this very day doing nothing but wound care. And if you look at the statute, he's not qualified to testify because the statute is very clear in subsection A that it must be the witness must have the same specialty as the specialty in which the defendant has been certified. This defendant has not been certified, so far as we can tell, in any specialty. There is a comment in the brief at one place that he's certified by CMAT, but I thought it very telling that his own affidavit, which really makes a good case about wound care and so forth, doesn't mention anything about certification by anybody in anything.
They're both parties, both doctors are certified.
Both doctors
plastic
are
surgery.
in plastic surgery, and as we pointed out in the brief, that specialty, according to the American Board of Medical Specialties, that's specialty. I'm sorry. I've been breathing the air on the way up here.
Don't.
That specialty encompasses treating wound care. And if you go back to Dr. Hallen's thank you.
There is some wound care. I remember the affidavit. There is
Yeah.
some evidence about wound care and,
Right.
but, okay, but your point is that on remand, the parties have to sort this out factually, and the trial court has to sort it out factually whether Dr. Holland can testify against, I mean, if it's all it is plastic surgery, then it's probably a sure bet that they're gonna, that's, at least under the statute, that Dr. Holland can testify, based on Baker.
As the record is today, Dr. Hallen, based on Baker, Dr. Hallen can testify, and with all due respect to counsel, her lack of wound care experience would go to the weight.
Right, yeah, but regardless, the point is, the issue before us is the statute.
Right.
And so for purposes of the statute, because Baker, the Supreme Court's decision in Baker now sets the standard, both sides need a chance to sort of analyze that, and the trial court needs a shot at that.
And I would submit the parties need the freedom to do whatever, now that we know the standard, to do whatever it requires to build their case. So I have nothing further unless there are more questions. Thank you very much.
Thank all counsel for their arguments. We will take this matter under advisement and issue a written decision in due course. With that, we stand adjourned.